What is the legal tightrope of fair housing and tenant screening? Imagine walking a narrow path where every step counts and one misstep could lead to trouble. That's exactly what property managers face when screening tenants while following fair housing laws. The goal is to find responsible tenants without crossing legal lines. The Fair Housing Act, which was passed in 1968, prohibits discrimination based on race, color, religion, sex including sexual orientation and gender identity, national origin, disability, and familial status. This means you cannot reject someone just because they belong to one of these protected groups. When screening tenants, most property managers look at credit reports, criminal background checks, and rental histories. But these tools can accidentally cause discrimination if used improperly. For example, if your screening criteria exclude applicants with past evictions that happen due to circumstances like job loss, that could be unfair. Or if you reject someone because they receive disability benefits or use housing vouchers, that might violate fair housing laws. To stay on the right side of the law, develop clear, written screening policies that everyone can see. These policies should be applied consistently to all applicants. For example, if you decide to check credit scores, set a minimum score like 650 points and stick to it for every applicant. Do not reject someone just because they have a criminal record if the crime is unrelated to the rental. Focus only on information that predicts if they can pay rent on time and take care of the property. Use relevant criteria only. For instance, recent rental history and current income are good indicators. Avoid using outdated or irrelevant information like old eviction records that no longer reflected the applicant's current situation. When using screening reports, verify the details carefully. Use multiple identifiers like name, date of birth, and social security number to avoid mismatches. It's also wise to be cautious with automated screening tools or artificial intelligence. These systems can sometimes produce biased results without anyone realizing it. Always review the reports manually before making a final decision. Even if you hire a third-party screening company, you are responsible for the final choice. Make sure the decision is based on fair and lawful reasons. If an applicant's circumstances are different, consider waiving or adjusting your screening criteria. For example, if someone pays rent through a third party or has a recent positive rental history, be flexible. Train your staff on fair housing laws and best practices to prevent unintentional discrimination. Failing to follow these rules can lead to claims of discrimination that impacts your property's reputation and finances. Both property owners and screening companies can be held liable if they violate fair housing laws. Keep open communication with your screening providers and document your processes. In the end, walking this legal tightrope means balancing effective tenant evaluation with strict adherence to anti-discrimination rules. Use fair, relevant, and transparent criteria applied equally to all applicants. This approach helps you avoid legal trouble and promotes fair and ethical leasing practices.